I don't know if this is on the agenda, but it relates to your getting up your control over the pipeline going to San Quentin. My name is Clayton Smith. I come from Mill Valley.
Mill Valley.
And the reason why I feel motivated to come here is because this, I think, is an issue that transcends just a parochial situation as might exist here in Ross Valley. The potential for the development of San Quentin, I think, is an issue that is going to have impacts for everybody who lives in the county. And I think that before the veto power that you currently have over what might transpire out there in San Quentin is given up, that a larger county-wide information and discussion of this issue should occur. At this point, I think most people in Marin County have absolutely no idea how far along this project has been moving, and particularly in light of Mr. Huffman's conversations recently on the topic that are getting a little more exposure. But I think that this is something that you need to, and when the excuse of cost savings is brought up, I think when you think of the consequences of this, the overall cost to the rest of us in this county, I think you ought to bear in mind that perhaps those costs that you're thinking that are so high now are really rather small when you consider the impact, the negative impact that the development, the hyper-intensive development of that peninsula would have on the rest of the economy. Not just the economy where I live, but actually even the economy of all the businesses that are in this particular valley and in the community that you're serving. Thank you.
Thank you. Next.
Yeah, hi, I'm Peter Hensel from Corte Madera, and I don't mean to be disrespectful of Mr. Gaffney, because I do respect people in public service, but I did read in the IJ in February that you had worked for RVSD for this since 1970s up to 2007. Is that correct?
Yes. Well, yes.
Okay. And then, but you haven't worked for them since then. But you have been working for Central Marin Sanitary District up until 2013. I would feel a lot more comfortable about your ability to be impartial and represent the interests of Ross Valley Sanitary if Central Marin Sanitary District wasn't the last agency that you gave advice to. That's my comment. And also, I would like to bring up what is a letter from the Fair Political Practices Commission that apparently they delved into whether you now you have a conflict of interest, and it says no, because you don't have an interest in Central Marin Sanitary District. Well, I understand you were probably on retainer. You were giving them financial advice because that's what you do. But then they closed by saying there was no evidence that participation in the settlement of a lawsuit between Ross Valley Sanitary and Central Marin Sanitation would affect the value of Bartle Wells. I mean, that strikes me as a very bizarre statement, because what is at issue here is whether or not you can correctly represent Ross Valley Sanitary. Thank you.
Thank you. Next.
Good evening. My name is Joyce Britt. I'm from Mill Valley, and I'm here tonight as a citizen of Marin to speak to a couple of issues. First, the matter of unintended consequences to which Mr. Smith referred. Unintended consequences in the sense of transfer of your asset may very well result in growth that most of the citizens of Marin do not want to see. Another matter is with respect to the lawsuit I think that in view of the comments, I should say the opinion of the trial judge who decided the matter of the summary judgment motion, I think both that and the other issues which relate to conflict of interest, that it would be absolutely best for there to be an open forum for discussion of these matters. Right now, our county has a lot of clouds over it with respect to public participation and public awareness, public knowledge, public notice. So, you know, if you think that the matter will be closed by a settlement, unfortunately, matters of conflict of interest rarely are. And so I think all of you need to take a very close look at the legacy that you want to leave as a result of your years of public service, for which I, and I'm sure everybody in this room, congratulate you.
Next.
Hi, Nancy Okada. I'm from San Anselmo, and I've been to previous board meetings. And I want to, once again, you all ran on transparency, encourage you to put this business out in the public's view. We need to all be able to see what's going on in terms of any negotiations that are going on between you, Central Sanitary, and San Quentin. There is precedence for this. We have provided you with that information. I believe some attorney is helping us, as well as I know I've talked to several other attorneys. And we really do need to be able to understand what you're negotiating and how you're going to settle this negotiation if you are going to settle it in public. It would probably be much better to go to binding arbitration, as has been recommended by numerous people who are far more knowledgeable than myself. And anyhow, that's what I would like to encourage you to not hold the closed session, but hold it out in public so that we may all see what's going on. And I would also seriously think about your reevaluating your legal team, because it seems as though there have been many missteps along the way. So thank you very much.
Thank you. Next.
Carol Page, San Anselmo. I object to the use of the closed session to prevent public scrutiny of the actions of this board. This is an improper ploy. It is abusive, irresponsible, and gives a strong impression you have something to hide. One person settling the future of this district behind closed doors is repugnant. On March 18th, you conducted an illegal closed session. Additionally, any gift of public funds, board actions supporting violations of contractual agreements that results in higher rates and overdevelopment of the district's service area are serious legal transgressions. I remind you, any vote taken to abandon resources of this district, impair function, and raise rates will be challenged. You have been offered options, alternative solutions, and been informed of legal impediments to a sellout settlement. Think carefully before you try to disenfranchise us who pay you to administer this district. I repeat this because you appear intent on your own agendas that are damaging to the future of Ross Valley Sanitary District. For example, meeting with those adversarial to this district while ensuring that those who advocate for the district either are outvoted or administratively silenced is a curious way for a board president to behave. Mr. Gaffney's repeated attempts to rebuff and stifle public inquiry while continuing to pursue his private agenda are beyond questionable. Fellow board members who share these ill-advised behaviors are equally vulnerable and liable. When CMSA discussed and voted on the settlement, the two directors elected to represent us in that JPA were barred from either discussion or vote on the issue. Yet Mr. Gaffney decides the future with impunity as he meets privately with CMSA, the county, and perhaps others about whom we do not yet know. Who needs the former counsel to the State Fair Political Practices Commission? Mr. Gaffney has not been indicted, merely asked to recuse himself from decisions where he may exercise bias. This is a reasonable request and expectation of any ethical representative, especially a public official participating in a governmental decision about matters arguably of material value to him. You have no attorney-client privilege here. You wrongfully invoke that claim. There is no Brown Act protection. Mr. Gaffney has breached confidentiality. The privilege is lost. Your attorney is informed of the deficiencies on which you rely. No trial date has been set for this litigation, but you are inviting another lawsuit. Binding arbitration is better than being sued again. The district has been cautioned by the courts, state and federal water quality agencies, fiscal watchdogs, and residents. There are consequences when you interfere with performance of the district functions for which the public is paying. Politics and public disenfranchisement have overtaken Ross Valley Sanitary's rightful mission, and for that you are culpable.
Hi, Joan Bennett from Kentfield. I've sent you numerous letters and I hope you've had an opportunity to review them. And some of the highlights I want to mention that are contained in those letters. First of all, I know that you've been asserting that the attorney-client privilege prevents you from providing us with the terms of the settlement agreement. That's not true. If you wish to provide us with the terms of the settlement agreement, you may do so. There's no law that says that you may not. If you don't want to provide us with the documents that were generated by your attorneys to you, then provide us with the documents that were generated by the defendants and given to you that contain the proposed settlement terms. Provide us with those. Let us know what's contained in them. Second, if you don't do that, I would suggest that the attorney-client privilege has been waived by your conduct in this matter. There were 2 PRAs that were sent to this district, one to Ross Valley Sanitary District by Basha Crane and another by Gerald Page to CMSA. And the documents produced in response thereof verify that what happened was that what I would call the Rice mediation was initiated by Director Gaffney. It was not initiated by Ross Valley Sanitary District's attorneys. You proceeded with this mediation without any attorneys present. They were expressly excluded by agreement of all parties. That was the preference stated by all parties. Therefore, there were no attorneys present when these discussions at the so-called mediation were conducted. Therefore, the attorney-client privilege does not apply to any of the discussions and or documents that were produced at that mediation, subsequent mediations, the entire series of the mediation. Therefore, produce those documents to us. If you're asserting that under the common interest doctrine, which is a part of the attorney-client privilege, that you don't have to produce those as well, you do. There's no common interest among the defendants and Ross Valley Sanitary District. There's no overlapping interest between Ross Valley Sanitary District and the defendants. You're adversarial in nature. Therefore, whatever was discussed at that mediation, you must produce to us as well. None of this was covered by the attorney-client privilege. Lastly, there was no confidentiality agreement produced in the PRA documents. It's typical, it's standard procedure that when you enter a mediation, all parties sign a confidentiality agreement, the purpose of which is to promote freedom of expression at the mediation so that no party feels inhibited, that what I provide to a mediator may somehow get back to the other side if I don't want that information relayed. And yet there's no confidentiality agreement by which you may prevent us from seeing the information as well. Lastly, based on all this, and it's been suggested numerous times in writing by me, by others, and it's been stated here tonight, probably the best resolution to this matter, if you don't want to incur more attorney's fees and costs at trial, is to enter an agreement for binding arbitration. And you may do so by which all sides will bear their own costs and attorney's fees. Therefore, you're not exposing yourself to paying for the other side's litigation costs. You may also agree to 3 arbitrators, 3 at your discretion. Each side agrees on them. You won't get stuck with a judge you may object to. Everybody will be happy with the panel you select. It's quicker, it's cheaper, and it's also not subject to appeal. So there will not be protracted appellate procedures. There won't be the cost that you would incur with proceeding with appeals. So if you go to binding arbitration, my estimate is you'd have this finished within 6 months, period. No more costs, no more lawyers. It would be over with, and it would be a resolution that the public more than welcomes. And you take your risk, whether you go to trial, whether you go to arbitration. You could win, you could lose. It's inherent in the nature of litigation. Getting out of bed in the morning is inherently a dangerous proposition going out on the roads. That is life. This is litigation. It can get tough, it can get nasty, but it's the nature of the business. And that's the business to which you were elected to conduct on the public's behalf. And you've heard over and over and over again, either share the information with us and or proceed to binding arbitration. So on that note, that's it.
Here, here. Here, here. Here, here.
Well, my name is Sid Bastian, and I only have one thing to say. I support Joan Bennett's recommendation for binding arbitration. Very strong. Thank you. Sam Rebell.
CMSA
Kathleen Mulcahy, City of Larkspur. And I got this postcard in the mail today, and I thought it was kind of serendipitous. It says to recalibrate. And it just seems like that's what needs to happen here. We just need to take and adjust and take external factors into account to allow for comparison. And I feel as though we've been dragging this closed session and litigation for so long that you're doing yourself an even further disservice by not, bringing us into the picture. That's all we in the Marin County area really want to be, is a part of what's going on. And I will thank Mr. Bornstein and Mr. Norby for publishing the 4 pieces of documents that I had requested and put online in regards to our concerns over Mr. Gaffney's potential conflict of interest. So that enabled us as ratepayers to look at that information and make some input comments, and that's valid. Out in next door, this Corte Madera council member on the CMSA board is also making some discussion points, and that's really helpful for us. As someone had mentioned earlier, that Congressman Hoffman has been starting to be more liberal in regards to talking about San Quentin. Your biggest fears are things that you'd rather tackle than to keep hiding, and I don't know if there's things that are being hidden in the agenda, or we don't know. So of course we all go to that place of fear, and maybe we don't need to be, but again, with this prolonged business, we really don't know what we're up against. So I just wanted to chat a little bit about transparency in regards to what's been going on. We just haven't gotten a lot from you guys as regards to the management of the board, except for just recently. But in order to get those 4 letters that got onto the website, we had to do a lot of meetings and asking and requesting and challenging. And that's just part of what the election body is all about, is challenging and bringing forth that information. So, Mr. Gaffney, I have in my hand all 4 of your public 700 forms. And so in regards to transparency, you had mentioned a couple of meetings ago, kind of touting that you were known to be, quite visible in the community because of all the clients that you've had in the past. So I pulled out the list on the website of your business, and there's, about 430. And so we've got, names like Association of Area Governments and the California State Community Development and Central Marin County and Central Marin Sanitary Agency and the City of Larkspur and Richmond Redevelopment Agency and the U.S. Army Corps of Engineers and the U.S. Environmental Protection Agency and the Corte Madera Sanitary District number 2 and East Bay Mud, and it goes on and on and on. Interestingly enough, Ross Valley Sanitary District didn't make it on your company's list of 430, so that was interesting. But when you filed your candidacy in what was received in the Marin County courts on March of 2014, you filed that you had no reportable interest on the schedule. So you stated a couple of meetings ago that you truly were elected because you got so much wealth of background, but you chose not to put it on your 700 form. So transparency again, in Marin we do much better with the truth than being not disclosed. And the second one, when you became an elected official, this was filed on July 28th of 2014. Again, you state when you were elected that you had no, agency ties whatsoever. And then we finally get a piece of information in regards to your annual renewal of your 700 forms in January 2015, which all of a sudden you begin to declare, a variety of stocks, which are very common for everybody, but that you are also a principal at Bartlett Wells Associates, and that you are a third owner in the real estate that firm runs for. And that would be true in regards to your recent filing as well. So you do have a connection. You do have a wealth of knowledge, because on the homepage from your company, you've got financial development and rates and bonds and all sorts of great things that you do bring to the table. But I think just because I've been in Arthur Anderson for a good chunk of my life, that there's a little bit of playing that goes on with the letters that were provided to the public in regards to the background. It goes, Mr. Gaffney reports that although he has retired as the principal of BWA, he does occasionally occasional consulting work with the firm at an hourly base. So I looked at your statements, your invoice statements for CMSA back in 2013. I've got them all here, and your rate, is of a principal and partner in my previous firm, Arthur Anderson, at 225, and then Jason is much lower at 135. But it's typical to bill at an hourly rate. That's just how it's done in the consulting firm. So when the reports that we're talking about the conflict of confidentiality and conflict of interest, your occasional consulting at an hourly rate, well, that is what consulting is about. So I would kind of argue that you're still really working for that particular company while sitting on this board. It also, in favor of yourself still being on this board and not influencing it in any way, I will say that it says here that BWA does have current contractual relations, does not have current contractual relations. But what I would argue to say, because it also relates in several of the letters of indirect, so I work for Bechtel as well. So both in my situations with Bechtel and working with government contracts, you get a foot in the door, then it exposes you or your fellow, other consultants that you work with an opportunity, along with a competitive advantage. So I feel that you sitting on the board is a high question. I looked at the letter that was quite in depth in regards to the Political Reform Act, and it in detail stepped through all 4 steps. And in step number 1, it said you met that situation. In step number 2, it met that situation. In step number 3, but in step number 4, it went into much detail about how you could look in regards to the financial feasibility. And so it came down to confidentially until all parties of litigation. Accordingly, I conclude that Mr. Gaffney does not have a disqualifying conflict of interest under the Political Reform Act. And they did that in regards to, because what you're doing, that we're not allowed to hear, all this confidentiality, it's actually, they're saying because we don't know what you're talking about and because it's confidential, that you're safe. And I find that kind of backwards, because if we could hear what you were talking about, maybe you would be, but we don't know. So you're kind of cloaking yourself, there's cloaking you under the confidentiality, because we don't know if it has any bearing on the litigation. And so we're just gonna take the high road and say, well, maybe it doesn't, so we're gonna let him carry on. I think us as customers would rather not have that. Okay, and I'll speed it along. And I'll get down to,
Maybe you let's
yeah, I'll wrap it up. Yeah. So I'll just read from today's paper. Mr. Spotwood did a nice little summary just of the audit findings, of which I kind of looked at our audit report in regards to looking at the 700 forms and CMSA actually publishing their forms. And I think you're on their board as an alternate, so that would, look at that situation as well.
CMSA.
CMSA is an alternate. Right, but he's your alternate, I believe.
All three are, other than.
Oh, because it says on the website that, right here, CMS Sanitary District, that Tom Gaffney is alternate Sanitary District number 1. So, that's what their website says. So, but they have out there their, code of interest, so all alternate commissioners, alone commissioners have to, provide all those things that are in the 700 form. So everything's really quite laid out. But I'll just read this little thing that Mr.
Well,
Scott.
wait a minute now, I think it's going on. How long is this going to be?
Well, I guess you can read it all today. So he did a nice little sum up of just, looking at the audit findings that have been going on in this board. And I think we as a public, have a lot of fear in what's going on. And I think if you bring it out into the open, if we're not doing all these closed discussions in regards to our property, we'd be a lot better off.
All right, thank you. Anyone else? Yes.
My name is Susan Kirsch. I'm from Mill Valley, California. I'll be really brief. I just want to speak in favor of Joan Bennett's proposal that this go to arbitration. And I'd like to just tie it in with some of the work that I've done in the community and in my professional life as consult with nonprofit organizations. And much of that work has been in the mental health field. And in the mental health field, there is just this principle that telling the truth and getting the truth out in as broad a way as possible always has a healing quality to it. And it feels like we're bombarded with things like the grand jury's last report about what's been happening in pension plans. And we know you've already gone through your own tough period with what's happened with the Ross Valley Sanitary District. So it's just encouraging you to be open to the public and let the public know and create really a new model for telling the truth, looking to see how we all face the truth as we've had to do it individually in our own lives, when we don't exactly like what we witness and see, but the importance of our agencies, all of our agencies, beginning as they recommend in mental health services to bring forward the truth and look at it and know, as the line in the movie was, yes, we can stand to face the truth. We can see the truth and we can emerge stronger by the fact that we've considered the truth.
Thank you. Anyone else? Okay, well, thank you all.
Well, I have a statement to make,
Okay.
for the closed session. At the last closed session on this issue, I made a presentation to our directors, to our board, and our attorneys. I handed out maps and information regarding the service area of the Ross Valley Sanitary District and a state law that impacts who may serve San Quentin Peninsula. My recommendations, my presentations was ignored. They were ignored. This is the official LAFCO map, Ross Valley wastewater districts. This is basically a blow-up of the map that was handed to our board members. And it shows the San Quentin Peninsula clearly in the planning sphere of influence of the Ross Valley Sanitary District and the urban service area of the Ross Valley Sanitary District. A state law passed in 2001, and it's Government Code 56-133. So, I'm really passionate about our business and what we're doing here and how we're trying to make amends with our communities. And at the same time, it's like the wheels are coming off the bus here on us. I'm being advised by two attorneys, both attorneys you've never seen at any of these meetings. One is considered the foremost expert in Brown Act law, Brown Act violations, and public records law. The other is considered an expert in interpretation of government codes. So, you know, I look to our attorneys for help, and I get no help at all, so I have to go out to private counsel and get information. According to this map, CMSA, Central Marin Sanitation Agency, cannot service San Quentin. They've been in violation of state law for 3 years, since they took over San Quentin State Prison. A quick glimpse of the law says, a city or district may provide new or extended services by contract or agreement outside of its jurisdictional boundaries only if it first requests and receives written approval from the commission in the affected county. And that's LAFCO law. I checked with LAFCO. CMSA has never gone to LAFCO to get approval for servicing the San Quentin Peninsula, either San Quentin State Prison or San Quentin Village. There's about 46 community homes out there, separate from the prison. There is an exception. That if two governmental agencies make an agreement, they can work this out. Except there's a condition on that exception. And it's under Section E, it says, this section does not apply to contracts for the transfer of non-potable or non-treated water. Sewage is non-potable. The attorney advised me, sewage is considered non-potable and non-treated water. Flat out, CMSA can't be on our side of the hill taking over the business here. But our attorneys ignore that. They ignore that. LAFCO is a state agency. Here it operates in Marin. I guess we've never checked with LAFCO to see what's going on. They currently have an ongoing study about sanitary districts and wastewater services and collections in Marin County. Lo and behold, we never do that. Our staff never checked with LAFCO to see what was going on. They're going to complete their study in fiscal year 2015-16. They hope to have the results out in January of 16. It includes wastewater services, collection and treatment for Los Valley Sanitary District, Sanderfell Sanitation District, CMSA, Larkspur, Corte Madera, and the Ross Valley Sanitary District. That study's ongoing right now, and we're going to fly in the face of whatever they come up with. What if they come up with the fact that, gee, San Quentin is in Ross Valley Sanitary District's sphere of influence and urban service area, and they need the service? It's going to be too late if we give it away. So, in conclusion, I'm telling you, I'm not going to attend this closed session. I'm not going to facilitate the violation of the Brown Act. I'm not going to facilitate the violation of state law. Section 56-133 is pretty clear. I'm not putting myself in that position. You elected me to represent you and to try to do my best to uphold the law. And so I will not attend this closed session on this issue tonight.
Mr. Egger started his comment by saying we ignored him.
I said our attorneys ignored.
No, Mr. Egger, you said we ignored you. Mr. Egger, I do not ignore you. I listen to every constituent. Those who I talk to out there will tell you that I call, I listen, I think about it, and I discuss. Mr. Egger, I listen to everything that you say, Mr. Egger, and I read everything you write. I'm sorry, Gerald.
No more comments from you.
I just wanna make one comment also.
I'm just taking offense that we ignore, we don't listen. I'm sorry, as a board, we may not agree, but we talk, we do, sometimes in closed session, sometimes not. But we do. And we have not had a meeting since Mr. Egger presented that which he's claiming we ignored. So there has been no time to discuss, which we can't do outside of this forum. So I do listen to what Mr. Egger says. I listen to what everybody says. I was elected to do that. You may not agree with everything I say, but that is just a true statement. And I took offense with that, so thank you.
And I'd like to make the point that something that Frank said was not true. We are well aware that LAFCO is considering the spheres of influence. That has been brought to our attention by our staff repeatedly, and in conjunction with our discussions about how a possible settlement will play out. So for Frank to act like he found something out that the staff didn't know about or this board was not aware of is an outright lie.
Secret contacts, you know, that stuff goes on all the time behind the closed doors.
You don't get to
You know,
lie about what our staff is.
I've never seen it in writing from our staff.
We just-
And if our
I have.
councils wanna risk,
Okay.
if they wanna risk legal malpractice, that's fine, let them go ahead. Because we've already hired a lawyer to look at possible legal malpractice by a previous attorney representing this district. The attorney said, you know, it's really tough to prove legal malpractice. Well, I think there's enough people out there that are so concerned about what this agency is doing that they're gonna look at legal malpractice issues.
That's not
Thank you
responsive to
very
the comment
much.
I just made, however. It's totally non-responsive to the comment I just made.
Here, no more public.
Well, the point is
No,
LAFCO's
no,
not
just
been
a
brought
minute.
into this
No.
conversation.
I've got a statement to make. This board approved it's basically a Brett Richards lawsuit against CMSA and San Quentin and Marin County in closed session. They did it. For 2 years before I got on this board, they had closed session meetings on numerous occasions with their counsel. And so I've been on this board for 6, 8 months, whatever it is. We've had the same closed sessions. I'd just like to say that. We're not the only ones that have had, just recently, the last couple of meetings now, Frank doesn't want to have closed sessions, but he's had them for years prior to this. And everything was done in closed sessions. And one of the people that made a comment a couple of months ago says, I knew nothing about this lawsuit. And frankly, none of you would have, except that, and not that we're trying to hide it, except that Frank brought it up. Because it's all done in closed session. Everything is done.
For you to call it a Brett
Oh,
Richards
just a
lawsuit
minute,
is
I
a
don't-
lie. It was voted unanimously by the entire board.
You're out
The
of order.
whole board. You are too.
Our attorney doesn't need to speak, please.
I'd like to say something. It's really sad to hear another board member call another board member a liar. That is really, to me, it's shameful. It's shameful. You know, you're voted to represent everybody, and this split board is really getting to the point where it's dysfunctional. So, you know, you guys have the majority. If you want to get down and dirty here, you have the majority. So you can sit and listen to the cows come home. But you guys all vote the same. And, you know, Frank's trying to point out to slow it down, listen to the public. You absolutely have to listen to the public. And I don't get that. I don't get that from some of the board members here. You just want to move on, it's closed session, we'll get all our advice from the attorneys and make a decision, and oh well. I hate to tell you, but this community is smart, and they are savvy, and they're not gonna take this laying down. So you majority, you go right on, you just go right on. But it's not gonna be the end of it, I'll tell you that.
What majority, Pam?
majority vote.
What
Michael.
majority?
The majority vote, Michael. Look at
Have
all
most of, have
minutes.
most of our votes since I've been here been 5-0?
The majority is 3-2.
Have most of our votes been 5-0?
Michael, I don't, this is, you're doing it already. I'm not gonna argue with you.
Well, then don't make comments.
Okay. We'd now like to adjourn to closed session. Okay, item 4C, report on action taken by the board during closed session pursuant to Government Code 549571. We gave direction to our attorneys and to staff. And
I
these are
have a
reported
comment.
actions.
I do want to say that this board, if they so do want to open up something to the public, they can. It's up to the board. That's all I want to say. That's all I can say.
Thank you.